Good. Should we wait a few minutes for the others?
So you telling me good afternoon, eh?
I said good afternoon.
I didn't hear you, ma'am.
Oh, okay. Good afternoon.
Good.
Hello,
Hi, Denise. How are you?
I'm good, thank you.
Oh, you sound so good. That 1 weekend off from me did wonders. Hey.
I love all time off, yes.
All right. Let's just give them 5 minutes to get in. You know, they kind of slow sometimes. To 5 more minutes. Ah, see, they're coming in.
I don't say morning. Good afternoon.
It's afternoon.
Sorry, good afternoon.
Okay, couple more. 4 more minutes and then we'll start. Anyone had a chance to read the chapter? I know, Denise, you read it.
Don't be so confident. But yes, I did. I did not like that chapter.
Oh, why?
Because my brief read did not give me enough understanding as it should have. So I reckon that it was pretty the concepts were more than I guess I was exposed to. So it's going to take a deeper read, you know.
Okay. All right. Anyone else read the chapter?
I didn't get a chance to finish it, but I did read like about more than half.
Oh, okay.
And it was a lot of information, like Denise said.
Oh, okay.
But this is a chapter that I'm really interested in discussing.
Ah,
So I'm looking forward to today's class.
Yes.
Did you have a chance to grade our midterms?
Almost,
No. Pardon?
almost finished.
Okay. The anticipation's killing me.
Why?
I just don't know, like, because this is the only like assignment we've done so far, I just can't even say, I can't even imagine how I did. Like, I just have to wait until I see what you say.
Oh, Lord, it ain't that bad. Come on.
But how, Ms. Arthur, can we ask how they're looking? I mean, from the ones you've done?
Yeah.
Or is it hard to tell? Like, you still don't know?
No. Christina on.
You looked at mine already?
No, so far, because I marked by question, not the full paper.
Oh, you marked by question?
Yeah, I've marked
okay.
3 of your questions, and they weren't too bad. No, they weren't too bad. Oh.
Okay.
Question 3, I'm still thinking about. I'm trying to figure out where you're going with that one.
Okay.
Back. And let me see. I looked at Denise's. I've marked some of hers. Her question number 2, I don't know. It wasn't bad, but then a lot of people answered question 2 differently. The one on the promoter. I thought by just throwing in the dates, that would have been sufficient enough for everyone to see that he had purchased the property before he became a promoter. So some people gave before and after. Some people said it was unclear when he purchased it, and then some people just said it was done prior to.
Okay.
Yeah. The first one was not too bad. the first question. It's just that quite a few persons just dropped in the name of Solomon when they were comparing the partnership versus a company. And they just dropped in the name of Solomon and not bringing out the principle from Solomon or a little summary of what happened in Solomon's case. Remember, that is the leading case on company law.
Okay.
And then on number 3, let me turn to 3. I passed 3 just now. Oh, number 3 was on the Articles of Association. Changing it, that was not done too bad. Some people forgot that you can actually go to the court. That wasn't, let me see, this one is, no, that one wasn't bad either. And no, that one wasn't bad. What did this one miss? Carolyn, you surely brief and to the point.
Sorry, Ms. Archer. Sorry, I've just joined. Good afternoon, everybody.
Hi, I'm just going through the midterm.
Mm-hmm.
Some feedback. I said you were surely short and to the point.
For which question?
Well, if I go to question 1, part A,
Mm-hmm.
you gave me 1, 2, 3 sentences
Oh,
for 10 points.
I got 10 points.
No,
Each question was worth 10 points.
no, 20.
Each question was worth
Mhm.
20 points. Okay.
Couldn't add 5.
Okay.
So like for Carolyn, her number 1A, because that had 2 parts. She got full points on B, but for A, she gave me 3 sentences. So I put a question mark.
Hmm.
Look
I
at-
probably was just thinking I had fully answered.
Look at A again.
Okay, let me pull up my exam. Yeah, that's a paragraph, Ms. Archer. You're just looking for more information, eh?
Of course.
Okay. Okay. I thought I just selected like the main points.
Mm-hmm.
Just in comparison to you know, the benefits and the drawbacks. So I sort of like I know there could be several, but I sort of like picked out a few of which I thought were really highlights or the most important. So that's how I came up with that answer.
Okay, let me see. Okay, but if you look at your answer, you're supposed to be comparing the limited company to the partnership.
Mhm.
So you haven't mentioned the benefits and the drawbacks of the partnership,
Mhm.
comparing the two.
I did. I think I did. Okay, like the benefit, the degree of flexibility, right? In the conduct of business, and then I said the drawback could be that there could be restrictions on the transfer of shares. The such would not need a prospectus because it's not a public. I mean, like a public company would. So a private company would not have, you know, the flexibility of issuing prospectus because it cannot issue shares. So that's a drawback. So I felt those two were the compared each other.
Yeah, so I said you were good at summarizing.
Mm-hmm.
Even question 2.
Mm-hmm. I am question B?
No,
Or
2.
question 2 itself. Okay. Mm-hmm. I could have elaborated more there too.
Yeah.
Okay.
And then question 3, you didn't add any cases if there were any. Some students did.
Mm-hmm.
I will
Yeah.
say, if I can interject,
Go
I
ahead.
will say that I wish we had gotten the midterm maybe the week before we did, because I feel like how you said Carolyn should have like answered a bit more in depth. I kind of didn't necessarily know what you were looking for in the responses, and I definitely didn't know the questions were worth 20 points each. I don't know if I'm the only one who didn't realize that, but I did have like quite a few questions that I was like, oh, I wish we had a class. So even though I did end up emailing you, as you know,
But you did answer in detail.
oh yeah, I know, but it took me a while to get started, and then like I was writing and I was like, maybe this isn't enough or maybe it's too much. So, and it had me a bit worried for the final, because I thought this was a bit difficult. I don't know if I'm on my own, but I thought it was a bit difficult. So, and I know the final is not take home. So,
Right. So you don't expect that much.
but would you like because it's not like this format for the final, right, where we would just be answering a prompt for the whole final. It would be some multiple choice, I think you said.
No. Would you like to
Oh,
have a choice?
yeah, I mean, I don't think I could go into the final and answer these questions like right off the bat unless like knew the prompts beforehand. Again, I don't know if I'm on my own with that, but
You are
normally-
100% not
normally-
on your own.
okay.
Yeah, normally for the final, I would tell you what are the areas on the final.
Okay.
So it's not, you won't be studying the whole manual or the whole last half of the manual.
Okay.
So it's actually narrowed down.
Okay. But that would be helpful. And some
Right.
multiple choice would also be helpful. Thank you.
So for question 3, again, Ms. Archer, like I thought I'd answered the question without having
No, you did.
to compare
You
with
did.
this.
No, you did, but I said that you were very good at summarizing.
Okay, because so for instance, with that question, right? I would not have thought to say compare it with a specific case or specific company. I just outright answered the question, like what would be required of them to amend their articles, you know?
Right.
So I was being guided by that.
No. Your answer wasn't wrong, I just said you were good at summarizing.
Summarizing.
What's
Okay.
right? Because what some of the other students did was they copied out the case that is in the manual and then they their answer.
Okay.
So to me, I figured, because I could tell the difference between the students. You were able to come and just summarize. Some, like how Christina was saying, she'll have to break it down in order for her to come to her conclusion.
Okay.
And assist her in getting to where she needs to go. It's not that your answers are wrong, I said that you summarize very well.
So these types of questions, there aren't really any wrong or right answers. It's just really how you present the answers.
Yes.
That's what you're also saying? Okay.
Yeah. You could tell when a person goes off. They don't state the principle first, which you would have gotten from the manual, and you went off on your own tangent, and obviously it'll be wrong. But you can argue both ways. So let's look at question 4 that I just started to read for you all, the one with the managing director, and the limit was 200,000, and she went ahead and negotiated the contract for 750. Remember the question? This was only
Yes,
last.
that one
I'm
stumped
looking at
me.
it, yes.
That stumped me, and I just couldn't. I initially didn't even feel, I thought that was pertaining to another unit we didn't even cover. I struggled with that one.
I looking right now at yours, Denise. I think. Yeah, I just started to read yours before I started the class. Okay, let me see. So listen to the question. Betty is the managing director of Tile Limited. She has decided the company should have a new warehouse built. She arranges for P Building Limited to carry out the building work on the usual standard term contract for the building industry, which requires that Tile Limited make progress payments on a 3-month basis. The Articles of Association of Tile Limited provide that the directors of the company may negotiate any contract on the company's behalf up to a value of $200,000, but contracts in excess of this sum must be approved by the company, passing an ordinary resolution in general meeting. The value of this building contract is $750,000. Betty did not obtain the approval of the general meeting. The first progress payment has now fallen due, and the other directors of Tile Limited have resolved not to pay it on the grounds that the contract was not properly authorized by the shareholders. So the question is, you're required to explain whether Tile Limited is bound to pay this progress payment, and then more generally, whether Tile Limited is bound to the contract with P Building Limited. Remember it now?
Mhm.
I couldn't forget that question.
Okay, so let's see where you. Okay, I read yours, Denise. You gave me some 5 paragraphs. Who's this? Althea? Let me see. One is not there. Okay, so what do you think this question is about?
Like authority or power to enter into a contract, like who has, I guess.
Yes.
Yeah.
Acting outside of the Articles of Association.
Mm-hmm.
Powers of directors.
Yeah. Go ahead, Christina. You're close to it. I'm reading your answer now.
I kind of answered it in 2 ways because, like Denise, the question like kind of stumped me a bit. But unlike Denise, I did not write 5 paragraphs because I think that was like the last question I answered.
What, question 4? Oh, what you mean?
Yeah.
Okay.
Ms. Archer, how do you know if you're answering correct? I mean, how do you know if like part 1 may have been correct where they were responsible for the progress and not for the total? Or you just have to, I guess, go by what the article said where there should have been, I guess, this resolution for up to 750 or above the 200,000.
Don't forget now, when you read these scenario questions, you have to make it practical. So in your mind, she is the managing director,
Right.
and she has entered into a contract beyond her limit. Okay? Now, put yourself in that shoe. Would you just off the cuff do something like that?
Okay.
So normally, if that's all the information that you have, you would preface your answer by saying, either you are making the assumption that she has the authority and has been making contracts on behalf of the company. Could have been within the limit or outside the limit, because she is the managing director.
Right.
Because if she has been acting outside of her authority, but it has been going on, no one has ever brought it to her attention, then she is bound the company.
Okay.
Well,
Now,
that's what I found unclear was that, you know, you had to, she definitely didn't commit a tort, and it was difficult to determine if it was negligence. So, chances are she just was probably not familiar with the fact that she could not authorize any or enter any contracts above 200,000. But like I said, it was difficult to determine, what angle to approach that from. Obviously, she acted outside of her powers, but I didn't know how to draw a conclusion besides, applying to the courts for them to make a decision, because and then whether or not the company had to honor the contract. I just didn't feel like we had covered that based upon the fact that we can determine if she was negligent or not.
Okay, but let's say if we took the other route and say she was aware, what approach would you take? See, there are different ways to answer this based upon how she got to this point. And remember, in all matters, everybody's situation is different. And that's why the answers are normally different. So unless the scenario is an exact scenario from a particular case, then everything is drawn from reading the scenario and you coming up with your own assumptions, your view as to how this matter may have taken place and what you're going to conclude.
I wasn't aware that that was how we were supposed to answer those. I didn't know that we were supposed to make a decision. Although the vagueness of some of the questions, I guess we had to kind of conclude, but again, I was caught between, not being able to conclude because there were not enough details, because even with, just to revert for a moment to the question about the promoter, you had gone in quite, in detail about that during the class that we covered that day, to say that, the promoter is involved sometimes way before the company was formed. So it was difficult, and I couldn't understand, I started to think, okay, definitely those dates are there for a reason. But I thought to myself, they're quite close. So perhaps, that was an inference that he had purchased that. Perhaps the inference was that he had purchased that in his role as a promoter, because I found it very coincidental that the four of them got together to form a company a year later, and just by chance he had this building that could be developed,
Yeah, but based upon your thought process, you could have, how it's vague, you could have stated your views as to what you saw.
Yes, I guess my inexperience, unfortunately, in answering questions such as these,
Yeah,
I was
you
not
could have.
aware that we
Now,
were supposed to do that.
Because it's a take home, do you all want me to stop? And some of you want to resubmit? Up to you.
Could
No,
it
I'm
be
finished.
that, yeah, I think so too, Ms. Archer. Could it be that you mark and then we have the option, or
Right,
does it
I'm with that.
like do a do-over? I don't know. If
is it that serious?
Yeah,
I think this is
I would
experience right here.
No, it's not that serious. But since some of you don't feel comfortable with the way you answered, like how Denise, you don't feel comfortable with that question. You may have wanted to just resubmit, but just change that answer.
No, I think that would be unfair, to be honest. I think, like I said, I think it's a learning experience. At the end of the day, it did, I found it very, very difficult.
So did
Though
I.
at the end of the day, I felt confident that, you know, I did my best to answer the questions. And if I was not on point, then like I said, it's a lesson, and, you know, I would learn going forward or what have you, you know?
Okay, I just wanted to see.
Sorry, I wouldn't want to attempt it again neither. That took me some time too. But you know, as we're now going through it, I think we're learning from what mistakes we may have made, and learning from each other, you know, as to what is expected, or how we could have answered the questions much better. So I like, again, I think too, it may not be fair to have us to resubmit, but to have us review the questions and see, you know, where we could have done better, or, you know, just go through it as a learning point.
Okay.
That's
All right.
me personally. I am speak for myself.
Yeah, no, I mean, like how Denise was saying that she wasn't too comfortable with that particular question. Just wanted to give her the opportunity, if she wanted to. We submitted it, and then she could have just say question 3, restate it, and then I could look at it. Because if you had a difficulty somewhere, and now that I've explained it and you wanted to do it, then I would give you that opportunity. Because I'm not giving you the answers, you see?
Right.
I'm just what I was expecting or looking for.
And I appreciate that 100%. But again,
No, that's
I don't
fine.
think it's, I don't think it's fair. It was just, and that I took it as my personal struggle, not necessarily a reflection of anything else. And it did make me very fearful of a final exam that's in class, because there is no way I could have answered any of those without the assistance of much papers in front of me and internet research, because I became very fearful of that final exam.
But don't forget now, this is take home. So it should be fearful. In the final exam, it's not like that. Okay, let's just say this was the final exam. This exam paper, the midterm, was your final exam. So I would have said to you, let's take question 2, which is on pre-incorporation. So I would say to you, we would have covered pre-incorporation. What happens before? What happens after, in the event that someone did a transaction on behalf of the proposed company or the actual company. And then I would say, and we also went through in those 2 same examples, the cases were stated as to who is liable for what and who can actually sue. With pre-incorporation purchases and post-incorporation purchases. So there is a question on that.
Would you be saying this stuff before?
Yes.
Or
On the last class.
Okay.
So you already know, first, one question is there on pre-incorporation. Either the person purchased it before or they're selling it to the shareholders. So you already know there's a question coming on that. So you just zero in on just that alone. Then I'll say there's a question on knowing the difference between, remember in the first chapter we did on the introduction of company law, we went through the Solomon principle, and we spoke about how it has perpetual succession and lots of other benefits. And you know that prior to incorporating companies, some people have a partnership and others have a sole proprietorship. So the question is looking at you comparing a company to one of the other 2. So you already know how it's coming.
And so actually you get points, I guess, too, on your interpretation of it, like once you can argue your case.
Yes.
Yeah, okay, so nothing is really right or wrong. Okay.
So for the final exam, there is no having to guess if page 96 of the notes will be there. Oh my God, chapter 6 is so long, all those shares, oh, where's it coming from? Alteration, reduction of capital, shareholders agreement, well, which part? No, I will tell you. Now, if you went, well, now you've asked for multiple choice. Multiple choice could come from anywhere from 6 to the end.
Mhm.
Or you could just stick to having 5 questions. We could add 1 as a bonus, but you'll know exactly where it's coming from except for the bonus.
Can we think about it?
Yeah, man. I haven't written it yet.
Okay.
Because you know to do the multiple choice, that's coming from anywhere.
One thing I found with this exam, you couldn't Google the answers. I was trying to be slick and try to research the answers, but you really had to refer to the text. I mean, like, I was like, okay, let me see if I could find the answer, Google the answer, but you really couldn't. So you have to really refer to the text, you know, the
Mhm.
material for the answers.
Oh, you wanted to Google me?
No,
Okay.
I was just saying, you know, I was trying to like beat the game, but then again, I found that you really cannot. You know, you have to know the material, you have to read it, and you have to, like I say, make reference to the material that you all provided. So there's no easy way out.
No. No, it's no easy way out. And then if you like Christina, if you have questions, you can just send an email.
Mm-hmm.
Not a problem. But yeah. But once I go over in the last class and I tell you what's on the exam, if you start to study, you made your little scribble your little notes, so you would have seen what I wrote, maybe what I said in terms of you, what area to cover, and you're reading it and you're not too sure if a certain part should be included in your study, then all you have to do is shoot an email and ask. So it's not that bad. But chapter 6 is on the exam. Don't worry about that. That is on the exam. Any other fears?
The one I stated still stands
Which one is that?
about the final. I mean, I don't know how. The thing is, okay, so I mean, now that you explained that the scenarios given with Betty and all the others, that they are left for our interpretation. Obviously,
You got off, Denise.
you know, offers a lot of, I don't know what you want to say. You know, it doesn't offer a lot of confidence to the person answering it. That is me. And so, but if it's just straight questions, I guess that would be a little better. But
Yeah.
I'm pro multiple choice for sure.
Well, that's up to you. Yo, anyhow, you also you wanted to think about it. So I'll leave it that you all want to.
In-person exam, because I can obviously.
Yes, in person.
No, I'm saying how much would be. Can you hear me?
Yeah, I can hear you.
Okay, yeah, I was saying how much would we be expected to write in the in-person exam?
No more than a page. And those pages are short, they're 8.5 by 11. And you don't need to rewrite the question.
Okay.
Yeah. It's not that long. I mean, because you would already known what's coming on the exam.
Okay.
You don't have to study all over the place.
So when could we expect to receive the grades for the midterm? When do you think you would have a chance to finish grading them?
I'll probably send you an email tomorrow.
Okay.
Mhm. Yes. All right, so all the fairs are over. Denise, you happy? See, Denise is making sure that her multiple choices on this exam.
No, I'm not happy. No, there was no, I'm still trying to recover from that midterm. I felt like I had a pretty good grasp of everything you had produced, but if I had to answer that midterm in class, besides the fact that it took me hours and hours and hours and hours and hours and going back to it to complete it,
Same.
there is no way in this world I would have been able to answer that in class.
No, if you had done this as a in-class company law midterm, I would have told you what's coming.
Even so, I would not have been able to critically answer any of those. But I mean, and maybe other people could. I mean, and I have experience, so I'm very, I felt grateful, but perhaps, I was off as well.
No, but so far you have not done bad at all.
Well, thank you. Like I said, I tried, and because of the effort, that is why I said, I'm not going to redo, and I just, it is what it is.
Yeah, but I mean, all that I've looked at so far, everybody has tried, and there's no one that has been like totally off course.
Great.
Yeah, it may have been a struggle at the beginning when you started. You may not have been too sure if what you wrote made sense, but so far, it's made sense. So you're not as bad as you think you are.
Can I jump ahead to the capstone? And I know we had discussed this already. No, but we'll see with the midterm, like Denise said, it did take a lot of time. So with the capstone, well, since that's still a couple weeks away, in my mind, I'm proactive. I don't know in like actuality how proactive I'll be, but I do want to plan to give myself a good amount of time to get it done. So you said question 1 is mandatory, right? And then it's choose 2 of the other questions.
Yes, and
Okay. No, I couldn't remember. So I just wanted to confirm
I
that.
think heading somewhere with that.
No, I just wanted to confirm that that's what we agreed on.
And then remember, I said you can do it in groups.
Right. So if we do it in groups, even if we do it in groups, we both have to individually answer number 1, or
No.
we just have to make sure we answer it.
No, one paper with both names on it.
Okay, so it's number 1 and then 2 of 2, 3, or 4.
Mm-hmm.
Okay, thank you.
1,
I
2.
thought it was only number 1 that we could answer in group.
Repeat that.
I thought it was the whole thing we could answer in a group.
No, I think just the first question.
The first
Oh,
question.
it's only
Only number.
Okay. Thanks.
And
So
then
number 1.
Then individually you choose between 1, 2, 3, and 4.
Oh, okay. Thanks.
Why you going so sad?
No, I just obviously misunderstood that. Brought me
Yeah.
back down to earth.
In a group, and then individually you choose 2 questions from the
Okay,
4.
thank you. Okay.
Okay. How's that coming? The capstone. Anyone started?
No, I was doing the midterm, but I want to start. That's why I asked.
Oh, okay. Okay.
Yeah, because I want to give myself a good amount of time. Because again, like Denise said, I was doing a lot of reading. You can't Google these things. So
Okay. I don't think there. Well, but you can Google the one that you're going to do with someone else. The mandatory question to research.
okay.
But I gave you all the link. So it's just
Okay, yes, you did.
so that one should not take a lot of time with 2 persons, or even if you did it with 3 persons, because really all you actually doing is looking at our legislation and looking at the changes that they've done in the UK and making a recommendation as to where you think our changes should be.
Okay.
Yeah. So if you and whoever you're doing it with decide now, look at it, look at the changes, and one person decide they're going to write on this section, someone say that section, then you have to spend more of your time answering the scenario questions. Because
Okay.
that first question is not that difficult in terms of doing your research and deciding what you want to write on. It's not long. It's not long at all. Anyone else on the capstone? No? So let's talk about shares and shareholders and capitalization. Exciting topic. So we start off by saying, what is a share? And a share is really an interest of an investor or shareholder in a company. And a share itself can be transferred by sale or by gift. Now, a shareholder has different rights in a company and depends on the type of shares that they purchase. And we'll come to the different types of shares later. And then we'll also talk about the different shareholders, because they're more or less like parallel based upon the type of shares. So when you talk about shares itself, shares come with rights. And that again depends on the type of share that the person has purchased. So the main types of shares are preference shares and ordinary shares. Some shares could be voting, some can be non-voting. Some shares could have even other additional rights attached to it. So when you talk about the general rights that are attached to shares, we know that you have the right to attend general meetings and to vote. And normally 1 vote goes with 1 share. You could also have non-voting shares, or sometimes you have shares with multiple votes. The second right you have is a right to share in the company's profits. And that means that when a company is making a profit, then you could be entitled to dividends. And the amount of dividends that you receive depends on the type of share that you have. And dividends can only be paid according to the provisions set out in the Articles of Association. The third right you have is on the distribution when it's the winding up or the liquidation of a company. You know that once a company is being wound up, the creditors are the first to be paid, and then the remaining assets are distributed amongst the shareholders or the members. So they could either have a return of capital or they could have a distribution of surplus capital. And again, depends on the type of share you have. Some shares have priority, such as the preference shares. And the fourth right that you have as a shareholder is that the company should be run lawfully. Because the members have the right, the legal right to sue and to make the company act lawfully with some restrictions. So like I said, the different types and classes of shares. You have ordinary shares, and they only have one vote. You are entitled to participate equally in dividends if the company is wound up, and you can share in the proceeds of the company after the debts are being paid. There are different classes of shares, and you can see this when you look at the stocks on BISX or on the US Stock Exchange or any of the stock exchanges. You'll see where they have ordinary shares can be broken down into class A, B, C, D, E, F, G, H, and keep going. And along with those various classes, they have different rights attached to it. And also you find that some of the ordinary shares have different nominal values. So the second type of share is a preference share, and preference shares have a preferential right to a fixed amount of dividend. And that dividend is normally expressed as a percentage of the nominal value or the par value of the share. And these shares are normally non-voting. Sometimes they are redeemable. And if there is a surplus after the discharge of all of the company's liability and after repayment of the capital, surplus is divided between the ordinary and the preference shareholder unless the articles provide to the contrary. And so normally, preference shareholders are not entitled to a share in surplus capital. Now, there are advantages and disadvantages of an ordinary share. The disadvantage is you're entitled to a dividend only after the preference dividends have been paid. The ordinary shares rank behind the preference shares for repayment of capital on winding up, or where there is a reduction of capital by repayment. So a preference shareholder is usually repaid first. So because the ordinary shareholders rank after the preference shareholder, they normally say that the ordinary shareholder holds the equity share capital of the company. Now, the advantage of being an ordinary shareholder is that you have the power to vote at general meetings. So the voting rights of preference shareholders are adequate if they can vote when their dividend is in arrear, on resolutions for reducing share capital and winding up the company, or on resolutions which are likely to affect the class rights. Another advantage of ordinary shareholders is that their dividends are not fixed, and they may increase substantially with the profitability of the company. So when you invest in a company, you can invest in ordinary shares or preference shares. Preference shares, of course, you get a better dividend. Ordinary shares, you may get a better dividend if the company is making a substantial profit. Another advantage is that the company may issue bonus shares for which the shareholder does not pay in cash, or they could make new issues with new rights at prices lower than outsiders would have to pay. And both of these are normally offered to the existing ordinary shareholders. So the general principle is that the rights enjoyed by one particular class should not be varied by the holders of another class of shares within the company. And that is, it is necessary to gain the consent of the members of the class whose rights are subject of proposed variation. And we'll come to that later. Non-voting shares, they carry no rights to attend general meeting or to vote. Is normally issued to employees as remuneration, and it's paid as dividends. And the preference shares are often non-voting shares. Redeemable shares, they're issued on the terms that the company will or they may buy them back at some future date. The date and the terms may be fixed. They preference shares are normally redeemable, and the company's articles normally stipulate the terms and conditions for issuance of redeemable shares. You can have deferred ordinary shares, and these have no dividend is paid until other classes of shares have received a minimum dividend. And then you could have management shares, and these carry extra voting rights so as to retain control of the company in certain shareholders' hands. They're normally used to allow original owners of a company to retain control after additional shares have been issued to outside investors. And you could also have participating preferred stock. And these shares give the holder the right to receive dividend equal to the customarily specified rate that preferred dividends are paid to preferred shareholders, as well as additional dividend based on some predetermined condition. The memo on arts may have provisions in it that give protection to holders of a class of shares against the rights on those shares being altered. Any comments so far on the different types of shares and the rights? That part is not too complex, right?
Right.
Okay, so now let's talk about the nominal value of shares. So a company may have shares of nominal or par value or no par value. So par value or nominal value or face value, that refers to the amount which a security is issued or can be redeemed. So a 10% bond with a par value of $2,000 would give you a $200 interest in a year. That par value has no relation to the market value of a stock. No par value does not have a redeemable price. Prices are determined by the amount that the investors are willing to pay for the stocks on the open market. So why would a company issue some shares with no par value? They do this to avoid liability to stockholders should the stock price take a turn for the worse. And then I gave you an example because it exposes the company to liability. So a no par value stock is issued without the specification of a par value indicated in the company's articles of incorporation or on the stock certificate. Most shares are indeed classified as no par or low par value stock. A no par value stock can still trade for tens or hundreds of dollars. It depends on what the market feels the company is worth. However, every share of a limited company must have a nominal value expressed in monetary terms. So why a nominal value? The significance of having a company limited by shares have nominal value on its shares is that the measure of a shareholder's liability to contribute toward payment of a company's debts is the nominal value of the shares he or she holds, unless they have agreed to pay an additional sum or premiums for the issuance of those shares. Once a shareholder has paid to the company a sum equal to the nominal value of his shares plus any agreed premium, he has discharged his obligation to contribute. So what's the definition of a share capital? Share capital is the amount that is contributed by the shareholders to the company's resources. The money or the assets which are contributed becomes the company's property immediately. The company does not become the shareholders' debtors for its repayment or restoration. The shareholder has a number of statutory and contractual rights against the company, among which are the right to share in its residual assets when it is wound up and to receive dividends out of its profits once they are declared in accordance with the Articles of Association. These two rights give a shareholder's share its value and make it saleable. So when you look at capital, there are different types. When I say different types, you see when you look at a financial statement, there are different wordings when you read the summary that speaks about the movement in equity. So nominal capital, this is the total of the nominal value of the shares which it may issue. This appears in the capital clause of the memorandum, and a company cannot issue shares beyond its nominal capital. The issued capital is the nominal value that have been allotted to the shareholders. The paid up capital is the amount that the shareholders have paid for the shares. The call up capital is the paid up capital plus unpaid up capital, which the company has called on its members to pay. An unpaid capital, which falls due for payment on one or more specified future dates under the terms of the issue of shares. Unpaid capital, if the company hasn't received payment of amount from its shareholders equal to the nominal value of the shares issued to them, the difference is unpaid capital. So the real value of shares. The value of a share is the price which a buyer will pay for it. And that depends on the number of shares offered by sellers and sought by buyers at any particular time. And so that's why the price of stocks or shares are constantly moving when you look on the stock exchange, because it depends on the performance of the company. It depends on the reputation of the company, whether there's been any negative news, whether the company is promoting a new product, whether or not the company is following ESG. So all of that is what you're looking at. Are they impacting the climate? All of those things bear into the stock price of a company. So the amount sought and offered for shares change daily, and so does the ruling price. So nominal versus the real value of shares. The nominal and paid up value of shares serves as a measure of the shareholder's liability to contribute towards payment of the company's debts and calculating dividend payments to which he is entitled. The nominal value provides no measure of the real value of the share. And remember now, the real value is the price that a buyer would be willing to pay for those shares. So company law is not concerned with the real value. Although the real value of the shares is of concern to the shareholder, company law is concerned with the nominal value. So the value of a share depends on the number of shares offered by sellers and sought by buyers at any one time. So the shareholder must pay the nominal value or greater issue price of his shares to the company in cash. Where shares are allotted by a company without any different method of payment, a company may also allot shares which are credited as paid up to an agreed amount for consideration other than cash. So whether share issued for payment in cash or for consideration other than cash, they cannot be issued at a discount. The allottee and any subsequent holder of shares are liable to pay the company in the amount of the discount in cash if the shares are issued at a discount. Shares are allotted for cash when the shareholder agrees to pay their nominal value or higher issue price by legal tender or by a check or negotiable instrument on which the company may sue him. Shares are also allotted for cash when the company is indebted to the shareholder and they agree that the debt will be discharged by crediting the shares as paid up by an equivalent amount. Note, a contract may be made for the allotment of shares for the consideration of cash or consideration other than cash, and may indicate the number of shares to be allotted and consideration provided. So, you know, once you have invested in the company, you receive a share certificate. And the share certificate is evidence of the member or the shareholder's title to those shares. The company normally issues just one certificate in respect of the shares issued, but the shareholder may ask for the share certificates to be split. At common law, a company will be prevented from denying statements in a share certificate against a person or entity that has relied on that statement. Then I just set out there the key information that can be found in a share certificate. So let's just say someone wants to transfer their shares. You can transfer your shares using the share transfer form. Usually it's at the back of the share certificate and has to be executed by the relevant parties. That's the transferor, the person who owns the shares presently, and then the transferee. So once that's done, the procedure is the resolution of the shareholders and members is prepared, and a share purchase agreement is prepared and executed. The existing shareholder, the transferor, executes the form by signing it and witnessing, and then the transferee executes it along with having it witnessed. And then the share transfer form is returned to the FCSP, and then it's recorded. The old share certificate is canceled. So we spoke about being able to vary class rights briefly. So under the Companies Act, Section 37, it speaks about the variation and abrogation of class rights. So the act states that if a company wants a share capital to be divided into different classes, and provision is made in their memo and arts to do so, it has to be done subject to the consent of any specified proportion of the holders of the issued shares of that particular class. Or they could sanction a resolution passed at a separate meeting of the holders of those shares. And in pursuance of such provision, the rights attached to any such class of shares are at any time varied. The holders of not less than 15% of the issued shares of that class. If they do not consent or vote in favor of the resolution of the variation, they can apply to the court to have the variation canceled. So an application has to be made within 21 days after the date on which the consent was given or the resolution was passed. And as the case may be, it may be made on behalf of the shareholders entitled to make the application by one or more of their number, as they may appoint in writing for the purpose. So the court, after hearing the application, may, if it is satisfied, having regard to the circumstances of the case, that the variation would unfairly prejudice the shareholders of the class represented by the applicant, disallow, and shall, if not so satisfied, confirm the variation. The decision on the court is final. And then the company has 15 days to forward a copy to the registrar, and the company and every officer of the company who is in default should be liable to a civil penalty of only $10 a day. So according to the act, variation includes abrogation. So if the shares of a company are divided into different classes, ordinary and preference, the expression class rights refers to the special rights of a particular class of shareholders concerning dividends and voting and rights on a winding up. This means that class rights can be extinguished entirely as well as merely varied, provided the appropriate procedure of the section settled above or followed. Class rights are to be regarded as varied only if after the purported act of variation, they are different in substance from before, or where the company proposes to make its existing cumulative preference shares non-cumulative. So unless this is so, consent of the particular class or classes of shareholders is not required. Now, the method of variation is, like I said before, it has to be in accordance with the provision of the articles for the variation of the class rights. Or if the articles don't make any provision, the holders of the shares of that class consent to the variation in accordance with the section. The consent is required under the section, any specified proportion of the holders of the issued shares of that class, and the sanction of a resolution passed at the separate meeting of the holders of those shares. And then, of course, a resolution to vary the rights of a particular class is of no legal effect unless the consent of the class is obtained. And it should be noted that any vote on a resolution to modify class rights must be undertaken for the purpose of benefiting the class as a whole. Now, a company can also alter its capital. Under Section 49 of the Companies Act, a company can alter its capital if authorized by the articles and by a resolution of the shareholders. So altering its capital means that it can increase its share capital by creating new shares. It can consolidate and divide all or any of its shares into larger amounts. It convert all or any of its paid up shares into stock and reconvert that stock into paid up shares of any denomination. It can subdivide its shares into smaller amounts. It can cancel shares as of the date of passing the resolution. And a cancellation of shares under this section does not mean reduction of share capital. So a company's share capital may be altered or increased, providing the company follows the appropriate methods and procedures. The alteration may increase the nominal share value. It can redivide the company's shares into shares of a greater or smaller nominal value, or the classification or reclassification of the company's share capital. So a limited company may consolidate its capital by amalgamating shares of smaller amount into shares of larger amounts. But it's rare for a company to consolidate. The trend is more to subdivide and go to lower nominal values because then it makes the shares easier to sell. You can have subdivision of the shares, and this is where the shares subdivide every dollar into like 10 shares of 10 cents each. The proportion of amounts paid and unpaid must remain the same where the shares are partly paid. And then I gave you an example. Now, in addition to altering its share capital, a company can reduce its share capital under Section 50 of the Companies Act. A company is limited by shares, and a company limited by guarantee and having a share capital may, if authorized by its articles by a resolution or shareholders reduce a share capital in any way, and in particular without prejudice to the generality of the foregoing power. They may extinguish or reduce the liability of a share capital not paid up, and either with or without extinguishing or reducing liability on any of the shares, they can cancel unpaid up share capital which is lost or unrepresented by available assets. And then either with or without extinguishing or reducing liability, they can pay off any paid up share capital which is in excess of the wants of the company. A limited liability company may reduce its share capital by special resolution confirmed by the court, or a private company limited by shares by special resolution supported by a solvency statement. An application is made to the court for confirming order, any objections by creditors, and settlement of objecting creditors. If the court is satisfied with respect to every creditor of the company who is entitled to object to the reduction, that either his consent to the reduction has been obtained, or his debt or claim has been discharged, or has been secured, the court will issue an order confirming reductions. The court may direct that the company add and reduce to his name until the expiration or time specified in the order and is a part of the name of the company. The court may also order that the company publish the reasons for the reduction in capital or some other information to the public. And then set out in that same section and under section 53 is the registration for confirming on the order and the minute of reduction, and then the liability of shareholders. So the registration to confirm is a copy of the order of the court confirming the reduction, and then there's a minute that's approved by the court, and in that minute it tells you the amount of the share capital, the number of the shares. And then on the registration of the order and the minute, notice of the registration shall be published in such a manner as the court directs. The registrar certifies the registration of the order and the minute. And then once registered, the minute is substituted for the corresponding part of the memorandum. The substitution is deemed to be an alteration of the memorandum within the meaning of section 29. And then subject to any claims by creditors, a shareholder of the company, past or present, is not liable in respect of any share to any call or contribution exceeding in amount the difference, if any, between the amount of the share as fixed by the minute and the amount paid, or the reduced amount, if any, which is to be deemed to have been paid on the share as the case may be. So then you have redeemable shares, and a company may issue redeemable shares, and they may be issued as redeemable at the option of the company or the shareholder. The articles of a private limited company may either exclude or restrict the issue of redeemable shares. But a public limited company may only issue redeemable shares if it is authorized by its articles. So if all company shares are redeemable, then this would circumvent the perpetual succession feature of a company. Redeemable shares may not be redeemed unless they are fully paid. The issued capital is the creditor's buffers, and this is the figure and not the paid up capital which must be replaced. Redeemable shares may only be redeemed out of distributable profits or out of the proceeds of a fresh issue of shares made for that purpose. Any premium payable on redemption must be paid out of distributable profits of the company unless the shares being redeemed were issued at a premium. The creditor's buffer in company law is the company's share capital plus non-distributable reserves. Notice to the registrar must be sent for any changes in the capital within 30 days of the share consolidation, division, subdivision, conversion, purchase, or otherwise acquired or canceled or stock reconverted. So a company may purchase or otherwise acquire shares issued by it. A company may not make any payment to purchase or otherwise acquire shares issued by it if there are reasonable grounds for them to believe that the company is unable, or it would alter after payment, be unable to make its liabilities as they become due. The realizable value of the company's asset would, after that payment, be less than the aggregate of its liabilities and issued share capital of all classes. The purchase or acquisition of shares under Section 44 of the Companies Act shall not be a reduction of share capital within the meaning of the Act. So a company may purchase its own shares for the following reasons. A private company may purchase its own shares because it gives their shares some marketability. If there is a death of a shareholder or the resignation or retirement of a shareholder, they would prefer for the company to purchase the shares rather than inviting an outsider to become a shareholder. If there is a shareholder dispute, a compromise can be reached by the company buying out the shares, again, avoiding the introduction of an outsider into the company. When an executive director who has taken shares decides to leave, the company can buy his shares so that he severs his ties with the company. So whenever a shareholder dies, his interest in the shares of a company passes to whoever inherits the shares under his will or under the rules of intestacy. The articles of association of a company normally provide the procedure for the transmission of shares of a deceased shareholder. So the person or entity to which the shares are willed or entitled under intestacy is required to show evidence of entitlement, either by a grant of letter of probate or letters of administration. And they present those to the company in order for the interest in the shares to pass in law. This is evidence that title has passed officially to the transmittee in law. And the transmittee may, subject to the articles of association, choose to become a registered shareholder or member, or they could transfer the shares to another person or entity for money or for consideration. Once the company recognizes and verifies the transmittee's entitlement to the shares, then the title to those shares must be properly documented in the share register, and a new certificate is issued. So just like how you have the different types of shares, you have types of shareholders. So a shareholder is a person or an entity who has a legal and beneficial interest in a company by acquiring and holding shares. So a shareholder can be a common shareholder, because that means that they have invested in ordinary shares. Preference shareholder, investment in preference shares. They could be a Class A shareholder or Class B shareholder. So they could be an ordinary shareholder where the shares are broken down into various classes. They can be a majority shareholder, and they could be a minority shareholder. And of course, they can be a nominee shareholder. So a nominee shareholder is an individual or a corporate entity that holds the shares of a company, either directly or indirectly, on behalf of the ultimate beneficial owner, and whose name the shares are registered in the share registry. And this is normally done for anonymity and convenience. One of the strict requirements is to have proper compliance framework to deal with knowing your client. And that follows the local Bahamian law on financial transaction, and also the proceeds of crime, and following international best practices. The nominee shareholder agreement is type of an agency relationship where the nominee shareholder, by holding a company's share in his or her name for the ultimate beneficial owner of the shares, they act as an agent on behalf of the UBO. As an agent, the nominee shareholder owes the same duties and responsibilities to the UBO as any agent would owe to its principal. And that's primarily to perform the duties imposed on him by the express or implied terms of the agency agreement. In this case, the nominee agreement between the UBO and the nominee shareholder, and to act strictly within the limits of the terms of the agency agreement and his actual authority. The potential liability that a nominee shareholder would incur would be primarily one toward the ultimate BO of the shares for breach of warranty of authority, if the nominee shareholder exceeds his actual or apparent authority to act on the principal's behalf. The principal may ratify the acts of the agent if desired. The provisions of the nominee agreement between the UBO and the nominee shareholder normally state clearly and comprehensively the nature and the ambit of the nominee shareholder relationship, the duties and responsibilities of the nominee shareholder, the extent of the authority of the nominee shareholder to act on behalf of the UBO in that capacity. With regard to third parties, the nominee shareholder has the same liability as an ordinary shareholder, and is liability for any amount that remains unpaid on shares issued to him in any company limited by shares. Any legal obligation or liability with regard to the shareholding remains the obligation of the actual UBO and not of his agent or representative. In order to provide nominee shareholder services, a financial institution must apply to the central bank for a restricted nominee trust license. The nominee trust licensee is a nominee company which has obtained a restricted license from the central bank to hold securities and other assets in its own name on behalf of clients of its parent bank or trust company, but carries on no other trust business. So, notwithstanding the nuances of a nominee shareholder agreement, one should note that under company law and in consideration of the legal underpinnings of an agency agreement, the shares of a deceased member of a company normally devolve on the personal representative of the deceased member's estate by operation of law. And the deceased member's assets are distributed in accordance with the provisions of his will or the rules of intestacy. So again, on the death of a UBO and subject to the provision of the articles, shares held by a nominee shareholder on behalf of an ultimate beneficial owner cannot be disposed any way that the company chooses, since the legal ownership of such shares is that of the personal representative of the ultimate beneficial owner and not the nominee shareholder. So shareholders have certain contractual and legal rights, and those are outlined in the memorandum and articles of association. Those rights are enshrined also in common law, and they're also enshrined in the statute. So shareholders may have rights, privileges, and powers, and those can be specified in the shareholders agreement. So the general law may protect shareholders of private companies from fraud, illegality, or the unfairly prejudicial conduct of the company's affairs, but it cannot protect them from the consequences of dissension within the company between its directors or members, because it's not the function of the court to review the merits of business decisions taken by the board of directors or shareholders. So certain protection of shareholders' rights should be drafted into the articles of a company in order to ensure legally and contractually the rights of shareholders are observed, protected, and maintained. Any comments so far?
That's a lot of information.
I just love this area. Beautiful for the exam.
I have a question, Ms. Archer.
Go ahead.
So if a shareholder dies, right? Intestate, and the new shareholder is obligated to sell their shares to the company? Because I mean, the first part of it was saying that the shareholders don't really like outsiders to hold shares in the
In
company.
a private company.
Okay, right, in a private company. So
Yeah.
would they want that person to sell the shares to them?
Yes.
Oh. That's strange. Could
Why?
that be like object, an object, like could the person say, oh no, I want to hold these shares in the company? Is it a must that they sell them?
It depends on what's in the articles of association.
Or the shareholders agreement?
Or the shareholders agreement, yeah, because we're just about to go through now some of the provisions people would put in a shareholders agreement.
Okay.
And that's why certain things should not be secretive. I mean, I know some people like to keep their private business private, but you see a lot of things happen at death. Because you may be thinking, okay, my husband say he owns 20% in this company.
Right.
I mean, he the dividends and all of that. And so everything is okay. Then he dies and you find out, okay, there are certain restrictions and conditions that are attached to these shares, and it's not what you thought it would be.
Gotcha. Thanks.
Yeah. So a shareholders agreement is a contract between the shareholders or the members of a company in which they agree how the company should be run. So the shareholders normally agree to use their voting power in the company to ensure that the terms of the agreement are complied with. And the shareholders agreement is a contract upon which they can be sued. And it binds each member to the other by the provisions that are outlined in it. So it normally is recommended that if you have 2 or more shareholders, you should draft a shareholders agreement. Because what it actually does is to protect all parties to the agreement against a majority of shareholders using their voting powers to the detriment of the other shareholders. Without a shareholders agreement, a company would normally be under the control of those who hold the majority of the votes at directors and shareholders meetings. So the typical provisions that you would see in a shareholders agreement are you require consent to be obtained from all or specified majority of shareholders to appoint and remove directors, payment of salaries or fees to shareholders, and extend company loans. Or outline which management decisions may be made by directors and what could be referred and determined by the shareholders. Look at acceptable company borrowing limits. Or a clause for dividend policy of the company to consider what percentage of the post-tax profit should be paid to the shareholders each year, and provide for when the company doesn't have to pay a dividend. You could also include the approval process for directors obtaining consent to be involved in a project or business venture which may conflict with his duty as a director. You could look at circumstances in which the shareholders may approve contracts, hiring practices, or the commencement of legal proceedings. Or you could look at a clause that has the effect of allowing the company to bring an action against, for example, a director who is misbehaving. You could include a restrictive covenant on the shareholders, which prevents them from competing with the business of the company. Or you could put in provision where any of the shareholders have given a guarantee for the company's liabilities and obligations, is that if those guarantees are called upon to be satisfied, the shareholders will split the cost according to their respective shareholding. Or you could put in a provision where it's usual to agree who the auditors and bankers, where the registered office, and what the accounting reference date of the company should be. And these matters should not be changed unless unanimous agreement is reached. So a clause to consider what should happen if one shareholder wants to leave the company. And without such provision, the shareholder may be able to sell his shares to anyone, leaving the remaining shareholders running a company with someone he doesn't know. With someone he does know, or the other shareholders could refuse to allow the shareholder to sell his shares. It is therefore important to have a set route in terms of how shares are to be sold. So what issues can arise if there is no shareholders agreement and reliance is placed on the standard articles of association? There is nothing to prevent a director from being removed by 50% of the shareholders by an ordinary resolution. In law, a company cannot promise to do or not to do certain things. A shareholders agreement could be worded to bind the company. All major executive decisions by the directors are made by a majority, including decisions to change the nature of the business. And it's very difficult to deal with the resolution of any deadlock through the articles. So when you look at shareholders and you look at directors, they have two different roles, because you will see sometimes on privately held companies, the shareholder may also be a director. So the shareholder owns a company, the director manages it. So unless the articles of association specify, a director doesn't need to be a shareholder, and the shareholder has no right to be a director of a company. But a shareholder can be a director. He doesn't have a right, but he can be. It is important to make the distinction between the shareholders and directors, not only to determine who owns and manages a company, but also to determine who can make decisions regarding the company in a directors meeting, shareholders meeting, or general meeting of a company. Some decisions may be made by the directors, but only with the shareholders' consent. The articles normally specify the requisite number of shareholders and directors, which issues regarding the company may be made by shareholders or directors, what meetings may be called or organized by shareholders and directors, how shareholders and directors may vote and participate in certain meetings, and what powers do shareholders and directors have in the ownership and management of the company. So the relationship between the shareholder and the directors is a complex one. Directors are subject to the general fiduciary duty to act in the company's best interest. They are required to account to the shareholders for the preservation and profitability of the assets of the company. So although directors are responsible for the daily operation of the company and to make certain key decisions that may affect the company, the shareholders of a company normally have the ultimate source of power, as they may have certain powers to appoint and remove directors or give their consent to major decisions. So when it comes to dividends, ordinary shareholders may be paid a dividend in respect of their common or ordinary shares only after the preference shareholders have been paid. If the preference shareholders by their terms of issues have priority for repayment in a winding up or on reduction of capital, only after the preference capital has been fully paid. Shareholders of preference shares rank in priority to shareholders of common shares. Debentures, debenture stock, loan stock and notes, and preference shares are known to an ordinary shareholder as prior charges, which means they have to be paid first. The ordinary shares, like I said earlier, are known as equities, or sometimes they're referred to as risk capital. So although payment of dividends for shares held by ordinary shareholders is postponed or subordinate to payment of dividends for preference shareholders, and although they bear the risk of the company's profits and assets proving insufficient, there are some advantages afforded to an ordinary shareholder. So where the preference dividend is fixed and cannot be increased, however large the company's profits, the whole of the residual profits of the company after paying the preference dividend may be paid out to the ordinary shareholder. In a winding up or liquidation, preference shareholders with priority for repayment of capital have been repaid the nominal value of their shares unless the preference shareholders are expressly entitled to participate in the surplus assets. The whole of the remaining assets of the company will be distributed among the ordinary shareholders. The ordinary shareholders may be able to receive back the nominal value of their share several times over. Most of the voting power at general meetings will belong to ordinary shareholders, and it is they who control the affairs of the company and appoint the directors. Due to the greater risk, the ordinary shareholder expects to receive a higher rate of dividend on his shares than is paid to the preference shareholders. So when the capital of the company is used profitably, the profits earned by the company should be more than sufficient to pay the fixed interest or dividend on their securities. And the excess profits will go to the fund out which dividends on ordinary shares are paid. The volatility of ordinary shares makes them known as risk capital. The higher the ratio of loan and preference capital to the ordinary share of the capital, the greater are the ordinary shareholders' expectation of high dividends when the company prospers. Conversely, the greater the risk of ordinary shareholders receiving no dividends or incurring a loss on their shares when the company experiences some adversity or hardship. So in a nutshell, that's capital. You learn about the different types of shares, par value of shares. You learned about capital, how capital can be altered, it can be reduced, it can be varied. Then you looked at the shareholders, the types of shareholders, the shareholders agreement, what happens upon death. Any comments?
It's a lot to remember.
But don't forget now, for example, I wouldn't just tell you there's a question on shares. I would tell you whether there's a question on alteration or is on reduction, or there's a question on shareholders' rights, or there's a question on the shareholders' agreement. So there's no need to panic.
I don't know if it's my area of practice that is perhaps so limited, but this application, I mean, are these concepts frequently applied? I mean, even the nominee shareholder, that is, the definition there is not anywhere near like what I am used to.
Okay, what's your definition?
Well, number one, it doesn't have to be, you don't have to get a license from the central bank in order to provide nominee shareholding. I mean, with a domestic company, more often than not, one of the shareholders always a nominee shareholder, so it's just an individual because of the requirement to have a minimum of 2, but also as a licensed FCSP, we have our own companies to provide nominee shareholding. And that's just evidenced by a declaration of trust, no nominee agreement, nothing like that.
Okay, so normally if you have in a financial structure with a bank would normally incorporate a nominee, a company to provide nominee trust services.
Yes, I mean, I understand the reference here, but I guess I am looking at this at like everyday application again, you know, and many of these concepts of shares, I don't know, besides a publicly traded company or a very large operating company, I wouldn't imagine that they'd ever encounter any of this, you know, any of these instances.
Yeah. But the act makes provision for it, and because it made provision for it, I say it's best to cover it. For someone to come out and say that they did a course in company law, and someone asked them if we were thinking of varying the shares of the company, and so the person may say, "What do you mean?" So it's just for information.
Yeah, I understand, and again, I guess I'm just coming from a point of view that it seems very remote, dare I say,
Yes.
And again, I'm just trying to bring it back to everyday business
Yeah.
in the Bahamas under company administration again. I would think that if any client came to us who wanted any sorts of these variations or to incorporate a company on this level, it would definitely be referred, they would be, we'd refer them to an attorney to draft those articles to incorporate, you know, these various, this
Mhm,
level of share descriptions and details, you know.
Yeah, you would make the reference for them or the referral for them to go to an attorney, but the administrator at least should have an idea of what it is that the client is asking for.
Yeah, I get it. I mean, it's definitely
Yeah.
an introduction to, you know, alternatives.
Yeah. But this chapter has evolved a lot from other classes where people would have asked a lot of questions about shares and capital and is expanded over time. So yes, it's not normal for, I guess, in the corporate world for seeing alteration and reduction of capital, like you say, unless it is a big public company. But we have had persons in the class who worked with public entities and they raised questions. And in some instances, they really even wanted to go even further in looking at the act.
Yeah, that's interesting. I guess every perspective is different because I mean, we deal obviously with increasing share capital, but that's by, you know, by resolution of the directors and amending the articles and submitting it to the registry, you know.
Right. Yeah. But it's not put here for you to memorize as this is everything that you need to know, but it just covers a little bit of everything. So don't hurt your head. But it's good to hear from your perspective. That
Yep,
is not
thank-
something, it's not something that you do every day. Because for exam purposes, then I know that at least in your case, that's not an area that you are familiar with.
No, for sure. I mean, you
Right.
know, the majority of our clients are international clients. And again, I say, you know, IBCs. So just the detail of the companies, I can even, you know, our domestic clients, for the most part, they are holding companies
just-
again, you know.
So they wouldn't even look at these features.
Definitely not.
Yeah. Christina, what about you? Christina, Shanice? Because it's good you said that, Denise, because then it helps me in terms of writing the exam.
Well, I'm happy my feedback can assist, you know.
Yeah, because otherwise I would have just pulled it from anywhere in chapter 6.
Yeah, I mean, my interest is more like even in a share transfer, you know, most articles or the standard articles say that a share transfer, the share transfer can be in any form that the directors deem fit, you know, and I always question that to wonder, so is a share transfer form even required? Because if the directors, whatever they accept as deemed fit would be whatever the directors, you know, deem fit. So if they don't think a share transfer form is necessary and they can just do it based upon, instruct us to do it based upon a resolution, you know, our MD, she pushes back and says, no, we need the share transfer form. But I reckon it says if the directors accept it without it, then that's what the articles state, you know.
Because the resolution would say, from Shirley May, comma, give the address of Shirley May. That's the person who's to transfer all. To Mary Sue, address so and so, shares in the amount of so and so. And so once it is clearly explicit and is signed by 2 directors or whatever the articles state you need, who needs to sign it, then that's it.
Yeah, but because somehow, you know, the interpretation is not so clear to some. So we insist on getting that share transfer form regardless, because
But
supposedly
I
that
think
is
that,
the evidence.
yeah, I think you're right. I think that is best practice. That is what has been done all along.
Yeah, I
Right.
get that, but when you have a pushback and, somebody's on the other side of, in Europe and they don't want to, and we, insist that that needs to be an original form. And if the directors say,
And that's
we're okay with it, I think it should be okay.
yeah, that's a piece of paper, more time, more tracking, another fee. No.
And the articles provide that it can be accepted in whatever form like I said, the directors deem fit.
Mhm.
So I don't know, what I find about corporate administration, which I thought this would assist with, is, quite often the articles of a company nor the act give clear indications in many situations as to how to administer the companies,
Mm. And the only way you could get like that same point you're talking about in terms of what the company sees fit is if there's a matter that goes before the court.
And whoever wants to do that. Because as I think about, applying to the court for reduction of share capital, I mean, so 2 years later, you get your reduction, who does that?
But I can for next class. Let me see if I could find anything that's maybe not close to, but let's see what I can find so we can see how the court thinks on certain matters. Because it's not that many, but I'll see based upon what I have. If something that's close, I talk about locally.
Yeah, I gathered that's what you meant. Sure.
Yeah.
That would be interesting.
Okay, I'll see what I can find. That would help.
Hi, Miss Archer. I couldn't get my mic unmuted in time.
Oh, no, go ahead.
What were you asking me?
I was asking you in terms of Denise shared with me that she does mostly IBCs. So a lot of the reference to the CAC in terms of reduction of capital variation, she wouldn't see that even with her local CACs. And I told her that's helpful in terms of me determining which questions to ask for the final exam.
Oh, yeah, I mostly deal with IBC. I actually only deal with IBCs.
That's
I
fine.
don't have any CAC companies.
Okay, anybody else? Carolyn?
No, my company fall under as a subsidiary. And so it set the mother company or they actually hold the shares. So those shareholdings never really change.
Oh, okay. All right.
So it's set out, it's actually it's a bank. So I mean, those they don't change. The shareholding doesn't change.
Okay.
I actually have not had much experience with the shareholding exchange either. Like probably maybe like a year ago when I was when I was working in another department, but in recent times, no. Which is why I was also just looking forward to going over this chapter because it's not something I necessarily see day to day.
Okay.
So, but in another form of place of employment, in company management, the most changes that would have occurred in shareholdings would have been the nominee shareholders. So that would have happened, whenever that person would have resigned from the company or would have severed ties with the company. Then if they were a nominee shareholder, then that would be transferred to the person replacing them as nominee shareholder.
Yeah, but under the same nominee company. Yeah. Okay.
Right.
I mean, we do share transfers, but I think maybe one or two companies might have had initially for some purpose ordinary and preference shares or Series A and Series B shares, but that fell away a long time ago. So now they just all issue ordinary shares. And although the shares may transfer, there's definitely no difference in the shares and the voting rights are usually all the same, et cetera, just
okay. I guess it depends on your clientele for the IBCs, because I know of some IBCs that have different owners and different classes of shares. And some of those are traded on the stock exchange.
That's interesting. Yeah, no,
Yeah, there are different structures. So some people come across different things. So that's why I wanted to ask. Okay. So now I know I'll just focus on IBCs and I'll make that simple. So you see how lucky you all are?
we lucky must be to have
Yes,
you.
thank
You
you.
can understand that. Thank you. I'm happy I spoke up and didn't just sit here and sulk.
Yeah, so I understand now. Okay. All right, so next week we're gonna look at company management. And I think most of you already got the hang of this, looking at how you answered some of the questions in terms of the directors, making decision that's in the best interest of the company as a whole. So this wouldn't be too bad. Maybe for this one, I'll see if I can find any local cases also. May not be on directors, maybe on shares, but let's see what I can find so I can share them with you all and we can have a discussion.
Okay, thank you.
Okay, all right. So have a good weekend and I'll send the grades.
Okay, thank you.
Okay,
and have a
wait.
good weekend.
All right then,
Okay.
bye.
Okay, bye, ladies.
Bye.
Okay.
Bye.
Take care.
Bye.
Be safe.